JEE IP Talks, our dedicated podcast where we explore the intersection between intellectual property, law, and innovation. I am Susan Akinade, an associate in Jacksonetti and Edu's intellectual property and technology team, and I will be your host for today's session. Today's episode is focused on a very important topic to innovators, to business owners, and to brands. And it's based on the topic patent prosecution in Nigeria. So, what's the goal of today's topic? It's to ensure that business owners, innovators know what's the procedure, the timelines, and the strategic consideration to the protection of their patent application in Nigeria. So today, I will be interviewing a senior colleague and partner in the IP and IT team, Ms. Tolu Olaloye, who works extensively with clients in Africa, Asia, and the Middle East region on IP prosecution and portfolio management. Ms. Olaloye, it's great to have you on this podcast. You're very welcome.
Thank you very much, Suzanne. I'm glad to be here and I look forward to walking us through this topic that we are having today.
All right. So today we have some very odd questions for you, straight to the point. So let me go to the first question, which is the foundation. So we just need you to give us a quick rundown of the major laws that are guiding patent prosecution in Nigeria.
I would say that patents in Nigeria are governed by a combination of domestic laws, international laws, and subsidiary instruments. And most of these laws are international treaties, and do not all the treaties are fully domesticated under the Nigerian law, but they are the core legal laws that we actually use in order to be able to protect patents. And some of those laws are one, the Patents Acts and Designs of 1970. We also have the patent rules of 1971, as well as the Paris Convention for the protection of industrial property. We also have the Patent and Designs Convention, Countries Order 1971 as well as the Patent Cooperation Treaty, which is called the PCT and was modified in 2003, and Nigeria ceded to it in 2005. All this law basically enables the international patent applicants to designate Nigeria when filing PCT applications. Although the PCT has not yet been domesticated by national laws, but applicants are able to file PCT applications at the Nigerian Trademarks and Patent Registry.
Okay. All right. So moving into the criteria, as an innovator today, what are the requirements I need to fulfill to protect my patents in Nigeria?
So I would say that there are basically some requirements that are necessary for an applicant to put in place or provide in order to be able to protect their patents in Nigeria. And under the provision of Section 1 of the Patents and Designs Act of 1970, an inventor must be able to provide these three core requirements. One, novelty. That means it must be novel, new. And the second requirement is inventive activity. And then the third one is industrial applicability. And industrial applicability means that it has to be something that is not only useful to yourself, but is useful to the community, to the people at hand. And that's why those three requirements are basically required, they're necessary for you to be provided in order to be able to protect your patent in Nigeria.
All right. So what if I'm working on an existing patent and I just want to improve it? Do I also have the right to protect such?
Oh, sure. Like I said, that a patent has to be new, novel, but also it can be an improvement on an existing activity. And that's why we have a lot of improvement in terms of technology, telecommunications, our phones, our fridge, our freezer. There are different models, and all those models are also protected under patent. So the patent laws allows you to have something novel, something new, or an improvement on an existing patent.
All right. Okay, so there's also a part about the newness of the patent. So what if I've actually disclosed the patent before I apply for it? Is there a regulation against that?
It's good to know that there's a disclosure at exhibition. So there is always an exception to that invention. So the law says that it has to be new. Nobody must have seen it before or used it. But we have an exception, especially where there's an exhibition, international exhibition. So if it has been officially recognized as an international exhibition and is within 6 months before the applicants file, then that's an exception to the fact that it has been heard before or been seen before you come to protect your patent.
Okay, so you mean that you have disclosed it at an international exhibition,
yes.
but within 6 months, I can still apply.
Yes, that's it.
All right. So who can apply for a patent in Nigeria?
Well, I would say that under the Nigerian law, the right to apply for patent basically lies with the statutory inventor and is the first to patent it, the first to file a patent application or validly claim a foreign priority, whether or not they are the true inventor, but the first to actually apply, go to the Nigerian Patent and Design Registry to submit an application for the registration. So the persons or entities that can apply are one, the statutory inventor, like I mentioned, the employer or commissioner of a work, also a successor in title, as well as foreign applicants. And that's why at the Nigerian Patent and Design Registry, we have the local applicants, and then we also have foreign applicants because the laws allows statutory inventor, employer or commissioner of works, a successor in title, as well as the foreign applicants to be able to protect. So those are the people that can apply for a patent in Nigeria.
So let's talk about the routes available for filing in Nigeria. What are the routes for filing a patent application in Nigeria?
Okay, so I would say that there are basically three main routes for filing applications in Nigeria, patent applications in Nigeria. And these routes are first, we have the direct filing, the direct national filing, which is the ordinary application. And it's just a simple, straightforward application. Then we also have the second one, which is the conventional application. That's the Paris Convention route. And then the third one is the PCT National Phase Entry applications. That's through the Patent Cooperatory Treaty route. So those are the three routes in which you can file applications in Nigeria. I would say that there are basically some differences between the Paris Convention and the PCT. That's the Patent Cooperation Treaty route. The Paris Convention is the route in which you are allowed to file your application in another country within 12 months, whilst the PCT application must be filed within 36 months. So, and patent is very, very peculiar, especially when it comes to deadline. They do not joke with deadline. So if you are an applicant or an inventor and you want to protect your invention in Nigeria, and you want to go through the Paris Convention or the PCT route, you must ensure that you meet up with the deadlines. The Paris Convention is 12 months and the PCT is 36 months.
Okay, so thank you very much. So as an innovator, when I apply for my patent application in Nigeria, is there an examination process for it?
Okay, so I would say that patent application in Nigeria undergo formal examination only. And when I say formal, so the registrar is basically going to look into the provision, whether your POA, the applicant's address, and all that. We do not have substantive examination in Nigeria. And substantive examination simply means that we do not conduct examination as to the novelty, the inventive step, the industrial applicability of the invention in Nigeria. What we have is formal application.
All right. So you just fulfill the formal requirements.
The formal requirements. But what I can see in practice, based on my experience, is that sometimes we see that the registrar might want to look into certain things, types of specification, which is a substantive examination. So what we all just try to do is to try and explain to them that according to the provision of the law says that in Nigeria we have formal examinations and not substantive examination. But in practice, sometimes we've seen instances where you want to see some examiners try to go into the specifications, and then we're just trying to draw the attention back to what the Patent Act says in Nigeria.
Okay. So thank you very much for that explanation and the practice perspective that you just given. So an applicant is not shocked that, oh, but I heard that it's just formal examination and that's all. All right, so when I apply for a patent application, how long does it take to get it to be granted in Nigeria?
Well, in Nigeria, obtaining a patent typically takes about 6 months from the filing dates of the grants, and then the formal procedure, the formal examinations of the patent in terms of acceptance will usually take 1 to 2 months, and followed by issuance of the letters patent, which would also take 2 to 4 months. So I would say, in general, I would say, give or take 9 to 12 months, your letters patent should be granted.
Oh, that's great. And quite fast.
Yes, it's quite fast. So I would say that in Nigeria, I think kudos to the Nigerian Patents and Designs Registry when it comes to the issuance of the letters patent. The timelines given is actually very good, and then they ensure that we get those documents out within. So I would say if a timeline for protection of patents in Nigeria will be 9 to 12 months.
Okay. All right. So going into the validity of a patent, how long does patents rights last in Nigeria? And then do I need to keep renewing my patents like trademarks?
That's quite interesting. So under the Patents and Designs Act, a Nigerian patent has a maximum of 20 years for the validity of the patent, 20 years. And within these 20 years, you are expected to renew your patent every year. So we call it annuity, like yearly renewal of the patent. But after 20 years, your exclusivity to that patent is done. So after 20 years, others can actually do an improvement on that your patent. So within that 20 years, you would enjoy exclusivity, validity. You can also enjoy licensing. You can also assign to them because you have the full ownership of the patent. But the maximum is 20 years, and after 20 years, it becomes a public domain, meaning that anyone within the public can take the patent and make use of it and do an improvement of what is already in existence. And that is why I would say that most of the invention we have today, if you look at cars, now we're talking about electrical cars. That's another patent. But before, all we had was, gasoline cars, we have diesel cars, but now we have electrical cars, and that's inventions. Those are, things that have come over the years in which we can protect.
So thank you so much. So we're going into what are the practical strategies that the patent applicant in Nigeria needs to have in mind when they're applying for a patent?
Well, when we talk about strategies that applicants need to put into consideration, I think some of those practical strategies are quite interesting. I would say first, you need to conduct a prior art search. And what does this mean? Find out if there is an existing patent before you. So you can conduct a prior art search. You should also engage a skilled patent draftsman because you need to draft your patent. You need to put the procedure, this inventive step that is being taken, you need to put them in a particular format. So you need to engage a skilled draftsman. And then you also need to appoint a registered patent agent, which of course I'm one of them. So if you have anyone that wants to register a patent in Nigeria, I'm very glad to be of help to them. And those are the things that you will need to put in place for you to be able to protect your patents in Nigeria. Those are the strategies to adopt. And for me, I actually find conducting that prior search very interesting because it gives you an idea of whether there is a patent that has been in existence before you or similar to what you have on board. Yeah.
All right. So, you earlier explained that in Nigeria, there's formal examination and then, there's no substantive examination. So why do I need to conduct a search when I can just submit all the formalities and then get my patent application?
Oh, well, I think the reason why you need to conduct a search is because Do not forget that we also have some PCT application that they've designated Nigeria, and also Paris Convention that they've designated Nigeria. And if you want to register, they might be able to cite them, or not even cite them. Those people can come and institute an infringement action against you, patent infringement, based on that. So that's why it's necessary for you to be able to find out if there is any prior art or invention that is similar to yours. Do not forget that whilst we're saying that they have formal examination, the owners of patents can also make use of the fact that if they see anything that is similar to their patent, they can institute an action against you, right? So that's why I would say that it's important to actually conduct that prior art search.
Okay, so is there search services for patents in Nigeria?
Yes, we have search services. It's one of the services that's provided by the Nigerian Patent and Design Registry.
Okay.
And is open to general public. But of course, like I stated, that you need to have a registered patent agent or lawyer that is experienced to be able to help you to protect your patent in Nigeria.
That's very great. All right, so moving into the next question, what are the common pitfalls that you need to avoid when in Nigeria?
It's quite interesting, because when we talk about common patent pitfalls to avoid, there's numerous ones, but the ones that just caught my attention and I would like to share with our audience today is basically assuming automatic grant. Some people just think that once I filed my patent, I already have automatic grant of the patent. That's not the procedure. You need to wait for the formal examination, then you need to get a latest patent issued. The second one is vague or overly broad claims. So we've in practice, we've seen a lot of people file patents, and those patents are just, the claims are, they are vague, they're overly, they're not really making those senses. And it's always very important that the applicants need to put that into perspective. Some of the pitfalls also is the missing priority claim deadline. I initially mentioned to you about the Paris Convention, which is 12 months, the PCT, which is 36 months. If you miss those deadlines, there are no extensions, right? So it's something that applicants need to put into place, and also ensure that they go to registered patent lawyers or agents to help them in this regard.
All right. Okay, so the next question is, can an applicant obtain regional protection through IWIPO OAPI Nigeria?
No. I would say no. And the reason is because Nigeria is not a member of either the African Regional Intellectual Property, that's the IWIPO, or OAPI. We are not a member of those two regional bodies. So in Africa, we have two regional bodies that protect intellectual property, IWIPO and OAPI. IWIPO is the English-speaking African countries that are made up of 22 countries, and we have the OAPI, which is 17 member states, but we are not members of these regional bodies. So this means that an applicant cannot designate Nigeria for IWIPO. So you have to basically obtain IP protection in Nigeria, and you must file nationally through the Nigerian Trademarks, Patent and Design Registry. So you can't file through those two bodies and designate Nigeria. No, it's not possible. You need to come to Nigeria, you need to file your patent and protect your invention in Nigeria.
Ms. Olaloye, thank you so much for today's insights.
So
that wraps up our episode for JEE IP Talks.
It's a pleasure to be here.
This guide would help you navigate the patent system with more clarity and confidence. For further information, we have an article. It's a detailed Q&A guide on patents available on our website at www.je.africa. So you can click the link to these documents just below this video. Thank you very much for joining us for today's session.
Thank you. I'm happy to be here.